This lecture would be devoted on property law and the children's share. So, how much share do children get in father's property? So, now we would like to discuss about their share on father's property. So, understanding how a father's property is distributed among children is one of the most commonly misunderstood aspects of family law in India. Many families face disputes and confusion when it comes to inheritance, especially between siblings or step relatives. However, legal clarification and consistent court rulings have now brought much needed clarity to this issue. So, we would like to discuss the share of children's share on father's property on different heads such as self-acquired property in regards to testamentary and intest and also regarding ancestral properties also in both the field testamentary and intest also on the third head, that is division of property among the personal laws that we found among the Hindus, Muslims, Christians, and also on the basis of testamentary and intest, also the rights of daughters, whether married or unmarried, as for Hindu Succession Amendment Act 2005 and Muslim Personal Law, then Hindus Indian Succession Act 1925. So also, whenever father dies intest without a will or without having testamentary documents, then it is equally among the class 1 heirs also. In case denial of property share by the father, then rights of adopted children as per the provisions of Hindu Adoption and Maintenance Act 1956 and also the rights of illegitimate children and also in case of rights of stepchildren as per the succession laws and rights on gifted property as per the provisions of Transfer of Property Act 1882 and also in case of children's share in case the father married second time or in the second marriage, also having rights of married daughters and sons and daughters as per the equal inheritance right, and finally we'll discuss the conclusion. So, property right for children as per the provisions. So, inheritance in India is governed mainly by personal laws based on religion for Hindus, Sikhs, Buddhists, and Jains. The Hindu Succession Act 1956 plays a central role. The Muslim community follows its own personal laws while Christians and others are governed by the Indian Succession Act 1925. So the key distinctions that we found regarding self-acquired property versus ancestral property. Then the second distinction that we found regarding testamentary with a will versus intest without a will regarding succession to property, then applicability of the personal law. So understanding the difference between there is a crucial In determining who gets what, so in that connection, would like to discuss what exactly the share of children on father's property if it is self-acquired. So, self-acquired property is the property that the father purchases while using his own resources and income. He has full rights over this type of property. So, a father can gift or will his self-acquired property to anyone, not necessarily his children. Children have no automatic legal claim on self-acquired property during the father's lifetime. After his death, if there is no will, the property will be divided equally among class 1 as per the provisions of Hindu Succession Act 1956 and as per regarding ancestral property there would be equal rights for all children as ancestral property is inherited by the father from his ancestors up to 4 generations. Children have a birthright in this property. As per the legal provisions relating to inheritance on ancestral property, sons and daughters have equal rights by birth in ancestral property. Even married daughters are entitled to an equal share as per the amendments made in 2005 to the Hindu Succession Amendment Act of 2005 and a father cannot will away ancestral property to outsiders unless legal heirs give their consents. And now we would like to discuss how property is divided among children. So the division of property depends on whether it is self-acquired or ancestral or whether the father died with or without a will. So as for self-acquired property, so here the property regarding share as per the will as we found under Indian Succession Act 1925 and as regarding self-acquired property also there will be equal share among class 1 as per the Hindu Succession Act if there is no will. And regarding ancestral property, these provisions are not applicable as per the testamentary will, as they will share equal by worth as per the provisions of Hindu Succession Act. And whenever the property is gifted, so it would go to the gifted person who owns fully as per the provisions of Transfer of Property Act 1882 and whenever it is under Muslim law as per the Shariat or the Muslim personal law as per the 1937 Muslim personal law, share of law applicable, so it would be applicable to all Muslim persons. And whenever it is relating to the Christian personal law, it is either we could say yes or no as the would be will or even they would get equal share as per the provisions of Indian Succession Act 1925 and regarding stepchildren also the answer would be either yes or no as per the provisions of the succession laws relating to the Muslims and Christians, as we know, among the Muslim community, there are basically two religious groups such as the Sunnis and Shias, so they have their respective legal views relating to such share in the properties. So also among the Christians, as we know, there are two groups such as the Catholics and Protestants, so it also depends either they would get a share and how the proportionate share one child will get on father's property in absence of a testamentary will. And finally, we would like to discuss about the adopted children. So, in that regarding, also they would get either a share or no share, as it depends on equal rights among the biological inheritance as per the Hindu Adoption and Maintenance Act, and in relation to Muslim law and Christian law, it would be according to their personal law. And now the question relates to the right of the daughters in father's property. So, daughters were not always treated equally in property matters. However, with the landmark amendment in 2005 to the Hindu Succession Act 1956, now it is clear that daughters would get equal compulsory rights. So, daughters have at present equal rights as sons in ancestral property. These rights exist even if the daughter is married. Daughters can also demand partition of property. And now the next one is that what happens if a father dies without a testamentary will? So, in that case, when the father dies in test without a will, the property is divided among the class 1 heirs, and this include a share for the widow, and another share would be among the sons, and also another share would be among the daughters, and the fourth share would go to the mother of that father who dies in test or without a will. So each class 1 heir gets an equal share in the property. So, as per the provisions of the Hindu Succession Act 1956, a widow would get 1/4, so also the son would get 1/4, and the daughter would get 1/4, and the mother also get 1/4. So the property of the father who died without a will or in test, then it would be equally divided among the four dependents such as widow, son, daughter, and mother. If there are multiple sons or daughters, the share will be divided equally among them. And now the next important question is, can a father deny property to a child? In the case of self-acquired property, the father can legally deny a child by writing a will. However, in ancestral property, children have an automatic right and cannot be denied without legal requirements of petition. So, a registered will is preferred for avoiding disputes. If the child has been adopted by someone else, they may lose their claim. Illegitimate children may have limited rights depending on the personal laws applicable. So, as you found certain legal misunderstanding prevailing among the legal heirs in relation to share into property, so many people believe that sons get a larger share or only sons inherit property. This is outdated and no longer valid under modern Indian laws. Sons and daughters are now equal in inheritance. A father's second marriage does not nullify children's right from the first marriage. The status of marital relationship of a daughter has no effect on her property rights. So, to avoid all disputes regarding a property which need to be shared among those legal heirs, there must be registered will early and updated when it needed. Maintain clear property records and ownership titles. Communicate decisions openly with all family members and to avoid always oral promises or unregistered property transfer. So, we would like to conclude our discussion relating to property law and children's share. So, Indian succession laws, especially under the Hindu Succession Act, have evolved to ensure gender equality and transparency in property rights. The share that children receive in a father's property depends largely on the nature of the property, whether a will exists, being aware of your legal rights and consulting any legal expert on property when one is doubt, and to avoid any kind of dispute. So, the very emphasis on this lecture is relating to children's share in the property of the father whenever it is self-acquired property or if there is the absence of a testamentary will or if the father dies in test. And in relation to ancestral property, even at the absence of a testamentary will, if the father dies in test, all the legal heirs would equally share their share in the ancestral property. And regarding division of property, there is the need of application of the respective personal laws of the Hindus. As such, the Hindu Succession Acts 1956 and the Muslim personal laws, as the Muslims having two major communities such as the Sunnis and Shias, so in some respect they differ in their personal laws relating to inheritance of property. Also among the Christians we found certain differences among certain different groups of Christian religious groups regarding their share in the property. Then we have discussed about the rights of daughters, whether married or unmarried, and how it would get a chance under the Hindu Succession Amendment Act 2005 and also the very provisions relating to Muslim personal laws, and also according to the provisions of Indian Succession Act 1925, which is especially applicable to the Christians. And whenever the father dies in test, then how it would be equally divided among the class 1 heirs. And in case denial of property, why the father then, in that circumstance, what would be the rights of adopted children validly adopted under the Hindu Adoption and Maintenance Act 1956? So also the rights of illegitimate children, as there is no answer is that they would not get any kind of share, but this very answer is limited, as because in under certain personal laws, in particularly among the Muslims and Christians, there is some limited rights available to adopted illegitimate children. And then we have discussed rights of stepchildren as per succession laws among the different personal laws of the Hindus, Muslims, and Christians. Then the question is relating to rights on gifted property, so it automatically goes to the property gifted by the person as per the provisions of Transfer of Property Act 1882. And another important question, if the father marries a second time, then in that case the children of the first marriage would definitely get a share of the property of the father and the position of a married daughter. How it was amended and changed under the Hindu Succession Amendment Act of 2005. And finally, we have discussed how the widow, sons, daughters, and mother would get equal inheritance right over the property left over by the father. So, finally, we have discussed the conclusion regarding property law and children's share as per the provisions of Hindu Succession Act of 1956, and as it was amended in 2005, so also the provisions relating to Indian Succession Act 1925 and the law prevailing among the Muslim major groups such as the Sunnis and Shias, also among the Christians as per the provisions of Indian Succession Act 1925.